Hey, it's Catherine Franke. It's May 22nd, and last night the House of Representatives, in the dark of night, passed by one vote the Republican budget bill, what they're calling the One Big Beautiful Act bill, or HR 1. Um, it's 1,118 pages long, and a lot of attention is being paid now to the cuts to Medicaid, other kinds of just fundamental cuts to programs that serve a wide variety of people in real economic need in our country, while rewarding rich people with more continued tax cuts. But there's one provision that hasn't gotten that much attention that's really worthy of note. As we well know, there have been a number of cases in federal court where federal court judges have found the actions of the Trump administration, particularly having to do with immigration and deportation, to be illegal, if not unconstitutional. This will continue because so many of the things that the Trump administration is doing is trying to test the limits of the law or just ignore the law altogether. And in those cases, temporary restraining orders or preliminary injunctions have issued. That is, legal measures that say, stop doing this, stop implementing this policy because it is illegal. So it's an order from the court for the government to stop the kind of illegal practices that they've been engaging in, like deporting people to El Salvador or using the old alien acts to declare people deportable. So this new provision that's included, that's kind of snuck in on page 565 of this One Big Beautiful Act, is described as a restriction on funds. And here's what it reads, is that no court of the United States may use appropriated funds to enforce a contempt citation for failure to comply with an injunction or temporary restraining order if no security was given when the injunction or order was issued pursuant to this particular federal rule, whether issued prior to, on, or subsequent to the date of the enactment of this section. So what this means is that if a court orders the Trump administration through a temporary restraining order or a preliminary injunction to stop doing something that the court has found is illegal or unconstitutional, and the government continues to do it, they ignore those orders, which, as we know, has been the case in a number of cases. The federal courts normally have the power to find the government in contempt, meaning that they can fine them, financial fines, or fine them criminally contempt by putting in prison the people who are at the head of the agencies that are ignoring these government orders. They can also find the lawyers in the Justice Department who are refusing to implement these orders as well in both civil and criminal contempt. But if, according to this provision, if at the time that those orders were issued, there had been no bond posted by the parties seeking to find the practices illegal, so whoever the plaintiffs were, the people who brought the lawsuits that said that this immigration practice, this other practice is illegal, and we want the government to be ordered to stop doing it, if they didn't post a bond when they did so, then the federal courts are unable, according to this provision, to find the government in contempt. So it renders those orders unenforceable, because contempt is really the only leverage the federal courts have to force the government, or anybody really, but in these cases the government, to do what they're ordered to do by federal judges. So with cases in the future, what you can do is post a bond of $1 or $2. Like, the judges don't have to require a lot of money, but according to this provision, if they haven't posted any bond, all of those outstanding existing orders, like the ones where they were sending people to Sudan or to El Salvador, etc., the government cannot be held in contempt because no bond was posted. Remember, it says prior to, on, or subsequent to the date of the enactment of this statute, so it's retroactive. which is quite unusual for a federal statute. Dean Erwin Chemerinsky, who's a well-known civil rights and constitutional lawyer, dean of the Berkeley Law School, has written a piece calling this a terrible idea, and I commend it to you. It explains the whole process. But this has nothing to do with the budget. I mean, nominally it has to do with posting funds, but they're sneaking a lot of stuff in to this budget bill, this one big beautiful bill that has nothing to do with the budget at all, but that allows incrementally the Trump administration to act in lawless ways with no penalties whatsoever. And this is one of those provisions. When this bill comes before the Senate, which it's going to do next, write to your senators and say, I object to all manner of things that are in this bill, but particularly Section 70302 that has to do with the contempt power of federal courts.